SJC-13852, Commonwealth versus Jose M. Shaw.
Okay, Attorney Jacobson.
Good morning, and may it please the court. Haley Jacobson on behalf of Jose Shaw. All of the applicable self-authentication provisions here require an attestation. And an attestation is a written and signed certification that the document is a correct copy of the original. There is nothing on Exhibit 1, written or otherwise, that certifies that someone compared it with the original and that it is an accurate copy. Without that attestation, Exhibit 1 was not properly authenticated and it was not admissible and should not have been admitted.
Does an attestation have to use the word attest?
No, I don't think it has to use the word attest, but it has to use a word, certainly a word, which this one does not. And it has to use a word that signifies that.
What does the stamp or the raised seal of the BDC mean?
I think it signifies.
Along with Eric Donovan's signature.
I think it signifies, the seal itself signifies two things. One, it signifies the origin of the document, but doesn't certify the authenticity or the accuracy of the contents. And it also serves to affirm that the document present in court is the one that.
Why would the clerk's office seal it if it wasn't an exact copy?
Well, so I think this point answers both of those questions, which is that the raised seal certifies that the copy is the exact one that came from the clerk's office and not a copy of the copy, which was the issue in Duramo. And I think that is the reason that the clerk's office would put that seal on the document, to avoid that issue occurring again. So I don't think there's anything in the seal, in the nature of the seal, that affirms that the person in the clerk's office compared it with the original and ensured that it was accurate. And I think the appeals court's conclusion that the seal is sufficient is wrong for at least two other reasons. First, it's inconsistent with this court's definition of an attestation in Duramo, which is written and signed certification. Obviously here there's the signature, but there's nothing written. The second reason, I think, is that the appeals court's conclusion is inconsistent with the language of Section 76 and of Rule 40. In both of those provisions, the drafters use the word attest or some version of attest, as well as the word seal in other parts of the provision, for other attestation requirements.
I'd like to turn, if I may, to Section 76, because this was a language that puzzled me before. Can you tell me where the language of Section 76 indicates that it applies to court documents? Because it doesn't, we're not a department of the Commonwealth or of any city or town. And I realize that we have cases that have sort of accepted that Section 76 applies to court documents, but I didn't see anything that explicitly said that was the case while interpreting the language of the statute. And I'm curious because I can't, to be frank, I can't really see how the statute itself on its face applies to court documents.
So I think first I would say that I would disagree that the language of the statute Department of the Commonwealth doesn't apply to the courts. In Chapter 211B, which establishes the court system, that Section 1 uses the word department to describe, the trial court department and the district court department, the superior court department, and of course they are of the Commonwealth in the sense that it's part of the government of the Commonwealth.
So they're departments of the trial court.
And I believe that the trial court, the language of 211B says that there shall be a trial court of the Commonwealth which shall consist of the following departments. So I think that language of the Commonwealth there.
Okay, assume we disagree because it doesn't say that the trial court is a department of the Commonwealth.
I think that's fair. Even if this court disagrees that Section 76 applies, it ultimately doesn't really matter because Rule 40 applies, and Rule 40 also requires an attestation. And I don't think there's any difference between the attestation requirement in Section 76 and in Rule 40. So I think you know, it's an interesting question, one that might be helpful for this court to resolve, but it's not one that needs to be resolved to decide this case, and certainly not to decide it in Mr. Shaw's favor.
So are you making a categorical argument, or are you ever saying that substantial compliance would ever kind of rule the day?
I think I'm making a categorical argument that the seal, a raised seal, is not sufficient to attest to the accuracy of the copy.
But is that what the appeals court thought? I thought it was, and you're more familiar with this than I am, so let me know if I'm wrong. I thought it was the seal plus the signature on the first 5 pages that made the first 5 pages good enough for government work.
I agree that that's what the appeals court said, but the signature serves a separate purpose under the appeals court's decision, and I think my argument as well, that the signature serves the purpose of identifying the person who is doing the attesting. It doesn't satisfy the requirement of certifying that the copy is accurate, and I think that's what the appeals court said as well. The language in the appeals court's decision says that when the certifier of the official record affirms using both their signature and some other form of assurance, whether it be an embossed seal, et cetera, that the copy of the official record is genuine and true. So I think the appeals court's decision stands for the fact that the seal is enough to affirm that the copy is true, and then the signature certifies that it's a person who has legal custody of the record, which is required in the rule. That signature serves that purpose. And so, but even still, regardless, the signature and the seal together don't affirm that the copy is accurate. It doesn't in any way signify that the person compared the copy with the original and assured that it was correct.
This is an important thing to me, because it sounds like you're melding 2 different evidentiary concepts. When you're talking about whether or not the copy is an accurate copy of the original, that sounds a lot like a best evidence consideration. Authentication has to do with the proponent saying, this is what I purport to say it is. And in this case, we have the seal and the signature of the custodian saying, this is what I say that it is. And it was unobjected to. So I'm trying to make sure that I understand what your complaint is. Because you started off by saying, again, that the correct copy of the original, that's a best evidence concept.
So I think I would disagree there, that the correct copy of the original is an authenticity question. And I think if we zoom out and think about what the self-authentication provisions are doing, is they're, like Your Honor said, they're substituting for that witness testimony that would otherwise be required to authenticate the document. And if a witness came into court and said, I received this document from the Brockton District Court, that wouldn't be enough to authenticate that it is in fact what it purports to be, which is a correct and accurate copy of the original record. If it were not an accurate copy, that would not be what it wouldn't be the item that the proponent is purporting it to be. There needs to be an affirmation in order to authenticate it, not to address best evidence, but in order to authenticate that it is actually the record or a copy of the record from the Brockton District Court that is accurate and accurately reflects what happened in court.
So let's just go back for a minute. So now this wasn't objected to, right?
Correct.
So if it were objected to, whose responsibility would it be to determine whether or not this was a properly authenticated document, the judge or the jury?
I think it would be for the judge to determine.
The finder of fact, excuse me.
Well, yeah, here the finder of fact was the judge, but in a jury trial, I think it would be for the judge to determine whether an item is authenticated, because that's a question of admissibility, not a question of the weight of the evidence. The evidence has to be authenticated in order for it to be admissible.
And what is the quantum of proof to that? Isn't that preponderance of the evidence?
I believe that is true.
So that's to get again to my point. So if the whole point of this is it more likely than not a document from the Brockton District Court, and you've got the sign, you've got the seal, why doesn't that, and it was unobjected to, why doesn't that work against you?
So I think I agree that it's more likely than not this document came from the Brockton District Court, and the seal and the signature show that. I don't think anything on the document show that it's more likely than not that this is a correct, accurate copy, because there's nothing on the document that affirms that. I would also say that even though the standard might be a preponderance of the evidence, there is a statutory or at least a rule requirement that the document be attested. And I think that is to avoid a situation where we are unsure of whether it has been compared with the original.
Well, the rule uses conditional language may, not shall.
So I think the may language in the rule is to say that the document may be admitted if it's attested, but
No,
that
it says
doesn't
may
have
be
to
evidenced. It doesn't say about, it doesn't attach the may to admitted.
Oh, I
It attaches
apologize.
the may to evidenced. In other words, it says it may be evidenced by an official publication thereof or by a copy attested by the officer having legal custody of the record. Now, I suppose there's some wiggle room there, but it doesn't seem to, the rule does not seem to foreclose the possibility of attestation by other means.
Well, I think what the rule doesn't foreclose is another means of authenticating the document, which certainly the document could have been authenticated by, for example, a witness coming into court to testify to its authenticity, or by some other means that, you know, is listed in rule or in rule 901 of the Guide to Evidence. I don't think that that means that a document can be self-authenticating in some other form not contemplated by the rule. Otherwise, there really wouldn't be a purpose to the rule if it could just be self-authenticated in some other way that is not contemplated there. Turning briefly to the question of prejudice, the question on substantial risk is whether the error here materially influenced the verdict. The error here is admitting the unauthenticated document. And that error undoubtedly influenced the verdict because it was that document was the only evidence that Mr. Shaw was convicted of a predicate offense, which is an essential element of the sentence enhancement. And I want to emphasize here that the question is whether Mr. Shaw was prejudiced by the admission of this document at the trial that actually happened here, and not what would have happened at a hypothetical trial where this document was properly authenticated and properly admitted. I think I would like to point the court to kind of a helpful illustration of the point that I just made, which is the drug certificate or non-testifying expert reports cases, like the appeals court's decision in Perez and this court's decision last year in Nacimiento de Pina. In both of those cases, the court is not looking to whether the same evidence could have been properly admitted at a hypothetical trial, even though it undoubtedly could. Those drug certificates could be admitted, the same exact ones, if the correct witness was there. But the court is not considering that in the substantial risk analysis. Instead, the court is looking primarily to the role the erroneously admitted evidence played at the trial that actually happened. And that's what Mr. Shaw is asking this court to do now, to look at the evidence here, see that it was the only evidence of an essential element of the sentence enhancement, and to vacate the sentence enhancement.
Can I go back and ask a question about the, following up on one of Justice George's questions? I think you agree that if it had been objected to, the judge would have to decide by a preponderance of evidence as to whether it had been authenticated. In making that judgment, do you think the judge could take into account the nature of the record that's being handed to the judge?
Yes, however, the nature of the record is addressed by Rule 40. It is a record, a public record. And so I think the judge has to take into account the requirement of Rule 40 that it be attested.
But here it's an electronic printout, correct?
That's correct, yes.
Of a docket system with which the judge is extremely familiar.
Yes. I think to the point of the electronic record and the question of a printout, I would just note that, first, it's entirely possible that a printout can contain errors. There can be a page missing. There can be parts of the printout that don't come through. So it's not as though the fact that it's an electronic record or a printout completely eliminates the possibility of inaccuracies. And I think this court, even though it was over 20 years ago, this court pointed that out in Duramo, that a photocopy doesn't necessarily mean that the record is 100% accurate, and it doesn't eliminate the requirement of an attestation.
The printout was numbered? The pages were numbered?
Yes, but not, page 1 out of however many pages. It just said page 1, 2, 3, 4, et cetera.
And we have case law that says that we presume that the docket sheet is correct and the official record of the proceedings, what do we do? Why would the judge not have been able to rely on that case law in making his determination whether to admit the document?
So I think for two reasons. I think the judge can't judicially notice an element of the offense, and that would be, or an element of the sentence enhancement, that would essentially be what presuming it to be accurate or presuming that it's, there's a conviction because this court record says so, would be an issue of judicially noticing an element of the sentence enhancement. And I would also say that Rule 40 applies to this question here, and Rule 40 requires the attestation. If there are no other questions, I would ask the court to vacate the sentence enhancement.
Okay.
Thank you.
Attorney Hanson.
Good morning. If it pleases the court, Arne Hansen for the Commonwealth. The issue here is whether or not this document was attested. And I think it's very clear based on Mass Rule 40A1, as well as the case law, as well as Mass Guide to Evidence 902, that it was. What we have here, to be attested, it needs to be a written and signed for certification that is a correct copy. Now, case law and the rules state that the custodian of the records must make this attestation, which is what happened here. It was Eric Donovan, who is the clerk magistrate of the Brockton District Court, signed the seal on top of it. Now,
Where does he attest that this is the actual docket?
The seal itself, I think, serves as the written attestation. I think the reason that courts use the seal is that it's not easily replicable. If you have a stamp or...
Counsel's argument that courts use the seal in order to determine whether it's the original versus a copy of the original.
Correct. I think that serves to show that it is attested. The seal is in the possession of the clerk's office. They're the only ones that are going to be able to put that seal on the document. It also serves, if you photocopy it and make amendments to it, the seal isn't going to show up because it's raised and is not, you can't duplicate it using a photocopy machine.
But how does the seal show that the comparison between this copy and the original was done?
It doesn't use very specific language, so that's, but it would show that it serves as a written attestation. Each page is stamped.
What do we do with the language in Rule 40 that says the certificate may be kept and then separately says authenticated by a seal of the court?
Right, so I think the certificate is only required when you're dealing with out-of-state records or from out-of-state courts. I don't think that's required within court cases from Massachusetts.
But if I could still go back to your earlier point, if the seal itself suffices, what's the point of the requirement of the attestation?
So I think the appeals court got it right. The attestation portion is two parts. It's the signature from the clerk magistrate or the custodian of records with some other form of assurance. And the examples they give are either a stamp that says true and attested copy or the seal itself. And I think that's consistent with Mass Rule 40, as well as the Guide to Evidence, as well as previous decisions from the appeals court. In Babcock, which I cite in my brief, it says that exact thing, that a signature on the seal is enough to authenticate a court document.
I think the difficulty is you get into a situation where suppose the document itself is 100 pages. And okay, if it's okay when you make the argument if it's two-page document, but if we're talking about something that's really important and it's multi-page, how do we satisfy ourselves if all you need is right at the beginning the seal and the signature?
I think the DiRamo case makes very clear that every single page within that document needs to be attested to, because there's nothing preventing someone from taking a cover letter, just putting a stamp on that, signing it, and then putting any other documents behind it. So I think it's important. It's unfortunate that someone's going to have to stamp 100 pages and sign 100 pages, but that's what is required here. And I think it is really a training issue with the trial court. I had one of my colleagues walk into my office as late as this Monday. I talked to him about this argument, and I thought he was joking. He came into me with a a prior from the Middlesex Superior Court. He said, is this authenticated? And, I thought it was a prank. And they had stamped the first page and sealed the first page, but the subsequent 10 pages had nothing on it. And I told them, you're going to have to get a different copy because this isn't going to work for you when you take this to trial. Now, with respect to prejudice, the defendant hasn't established prejudice here. I don't think we even need to get there because the document was properly authenticated with the signature and the seal. But I think it's clear here that they're not even arguing that the document that was admitted into evidence without objection at his trial had errors on it, which was the case in the Duramo case. And in Duramo, they took the copy that was submitted into evidence and they compared it to another copy that was in possession of the clerk's office, and they determined with material respects, there was no difference. There were some things omitted from one copy that weren't in the other. The Commonwealth could prove its case. And that's exactly the situation we have here.
Well, it's not, because in that case, it was a bench trial and the judge had in front of the judge the other copy, and that didn't happen here.
Yes, that's fair. The other copy that was obtained here, I obtained after the fact and for the purpose of evaluating the case on appeal to make sure that there weren't any errors in it, but there aren't any.
So does the Commonwealth get to prove its case on appeal by augmenting the record on appeal?
No, but I think the burden shifts to the defendant on appeal to show that there was an error, and the defendant hasn't done that in this case.
What's your best case for the proposition that we don't just take out if we find that, if we conclude that the shouldn't have been admitted, that we just don't look at all the evidence minus the exhibit?
I'm sorry, could you repeat the question?
Wouldn't our ordinary practice to be to just look at the evidence minus the wrong, improperly admitted evidence to decide whether there's prejudice?
Correct.
So how can we consider the document submitted by the Commonwealth on appeal?
So if you have to look at the Duramo case, you're allowed to look at the properly authenticated records. Which
That
is
was
what they
before
did.
the fact finder.
Correct.
And there is none before the fact finder here.
I would argue that the first 5 pages are properly
I
authenticated.
thought your prejudice argument went to the pages that weren't signed by the court magistrate, correct?
Right. So those pages, again, they're not necessary to show that he was convicted. And I think more than anything else, the defendant conceded that he was convicted of this crime. And that's on trial transcript 5, page 40, lines 6 to 10. So that's the first day of the bench trial. So they had the bench trial, they put in the witnesses, they made arguments, and then Judge Sullivan took a week to make a decision because of the ACG charge issue, which is, so there, on that page, the defendant conceded that was actually him. And what really he was doing was fighting the ACC2 case, saying that...
But that's a separate trial.
Correct, but we're only discussing the bench trial.
I know what you're saying, but are you saying that at the separate bench trial on the enhancement component that the defendant is entitled to, that the judge can use evidence that was admitted from the first trial?
The evidence wasn't admitted in the first trial.
But no, the admission.
No, that was the...
Was the admission as part of the enhancement trial?
Correct. So transcript 5 is the first day of the bench trial.
What page are you specifically relying on?
Page 40, lines 6 to 10, Attorney Green all but concedes that the Judge Sullivan could find that the defendant was convicted of the drug offense, where he acknowledges that it was a certified record from the Brockton District Court that reflected that conviction. And obviously, identity was never an issue here either, because we had 3 officers identify the defendant as that person, including the booking officer in the case at bar, as well as the booking officer for that 2001 conviction. If there are no further questions, I would rest on my brief.
Thank you.